So today we will discuss about the legal risks faced by valuers. So here we will discuss about the different cases which were taken by IBBI against the values, and we will discuss about what type of cases that were, what were the problems in these valuations, what are the legal actions taken by IBBI, and then we will take the case taken by other authorities such as IBA. Though IBA is not a government authority, but being an association of bankers, they sometimes take action against the valuers who have done something wrong in the banking valuation sector. And then SEBI also, in some cases, SEBI has also taken action against the valuers for doing wrong valuation. So, what were these things which the value should have taken care of? So, as far as legal regulatory framework in India at present is concerned, so there are multiple authorities. You know, I on the one hand IBBI, which registered valuers for valuers under Companies Act. Then you are doing valuation for banking and financial institutions. Then you are doing valuation for capital gain purposes, for which valuers are registered under Section 34 AB by CBDT. And then in certain cases, SEBI also, you have to do valuation. There also they have their own procedure, they have their own standards. So because of that, whenever you are doing valuation, first of all, you have to check for which authority, under which authority this valuation will be done. And you have to follow the rules and regulations of that authority. That is important thing. So the rules, as you know, we now first of all we will discuss about the rules and regulations of IBBI and what were the types of violations and what were the actions taken by the regulatory authority against them. So, as far as IBBA rule is concerned, you know, for registration of valuers and for valuation, the main section which is important for us is section 247, under which we are registered as valuers and we do valuations for companies and so section 247 of the Companies Act, it mandates that a company can only conduct valuation by an individual or firm that is registered valuer with a recognized valuation professional body. So, and the registered valuers and valuation rules 2017. So, for registration, doing valuation under this act, you have to be registered with the first. You have to register with the RVO. Then you have to go through a training of 50 hours. Then you have to register with the IBBA authority. Then you have to take a certificate of practice, and only then you can do the valuation under section 247. And these rules are under section 247 of Companies Act 2013. And again, this act was of 2017, which gives the rules for the values, that how the valuation is to be done. What should be the specific qualifications of the registered values, how they are to be registered, and how they have to do the valuation so as to ensure credibility of the valuation process. So some key features of the law, first thing is registration requirement, as we have already discussed. Then code of conduct is given by the IBBI rules. So for that, values must adhere to the strict code of conduct, ensuring that valuation is independent, transparent, and impartial. And then there is disciplinary mechanism if someone do any violations. Then IBBI can initiate actions against the valuers, including suspensions thereof or cancellation of their registration with IBBI. So, what types of violations are there and what are the regulatory response to them? So, violation by values falls into one of the several categories. So, mainly the violations were first type of is negligence in valuation practices. So then lack of independence, then failure to adhere to the ethical standards, or misrepresentation of asset values, or failure to comply with the regulatory guidelines. Generally, the violations comes under these categories. That is negligence of valuation practices, lack of independence, failure to adhere to the ethical standards, misrepresentation of asset value means overvaluation or undervaluation, or failure to comply with the regulatory guidelines of IBBI. So we will analyze some actual cases to highlight how IBBI has acted to uphold the integrity of valuation profession. Insolvency and bankruptcy code risks. So how the first of all you should know how the process of company valuation is done. First of all, you are asked by the company or the IP as the case may be to do the valuation, to carry out the valuation means first thing is initial appointment. So when the initial appointment is done, what are the things which are to be checked by the person who is appointing you as a valuer? First thing is he has to check your registration verification, whether you are registered for that particular asset category for doing the valuation. Then they have to check whether there is any conflict of interest in the asset of which you are doing valuation. And after ascertaining these facts, they have to issue you a letter with clear scope of valuation. What are the scope of the valuation which is to be done with clear scope of valuation and terms and conditions. This is the first step.
Friends, I request everyone that before getting the letter of assignment or letter of starting the work, please do not take any step for starting the valuation. At the time of inspection or at the time of peer review, the first question by the inspection team is show the letter of assignment. If you're not having the letter of assignment, then 50% of your inspection may be in negative marks. Yes, sir. Over to you, sir. Please continue.
So then, once you got the letter of appointment, next thing is valuation process. You have to carry out the valuation process with due diligence, with comprehensive due diligence. Then it is your duty to find out which method you have to use, means methodology selection for doing the valuation. And then whatever assumptions you have taken for doing this valuation, they have to be properly documented. Means this is how the valuation process is to be carried out. And once you have done the valuation, then you have to submit the report. The third step is report submission. So it should be in prescribed format. If there is some prescribed format, then you have to use that prescribed format. For example, if you are doing valuation for CBDT, then you have to do form O or for doing the valuation. And if there is no prescribed format, then you can design your own format. Even if there is prescribed format, you can make additions to that if you think such information is necessary to be added in the valuation, your valuation report. So this is just the prescribed format is just for your reference, that these are the minimum things which are to be mentioned in the valuation report. And again, it is told that you can add n number of columns and number of rows to that depending upon the situation, depending upon the valuation. It is not amendment, it is just additions which you can do. And then you have to submit it to the tribunal or the person, client, whatever the case may be, with specified timelines. And after you have submitted your report, you have to answer the stakeholders' query responses. And in case if it is required, you may have to be appear before the tribunal or the competent authority, as the case may be. And you have to give support during the resolution process. This is especially for doing valuation under Companies Act. This is how it is to be carried out and how it is done. Now we will take certain cases of IBBI, in which valuations have some valuations done by the registered valuers have some violations. And what are the lessons we learned from these case studies? First case is negligence in conducting valuation. Here, what violation is done? A valuer was found to have conducted the evaluation of company's fixed assets without adequately inspecting the assets in question. So this is the valuer itself to be blamed. So it is your duty, first and foremost duty, to inspect all the assets of which you are doing valuation. So the valuation was using old financial data and ignoring substantial changes in the market condition. This led to an overstatement of asset value, which was later used in corporate restructuring, resulting in financial misreporting. So the name of the values or other things have been removed. This is just for your reference that how the case was, what was the case, and what were the regulatory actions in this case. Upon investigation, regulatory authority determines that the valuer has not followed the prescribed procedure for asset inspection and has relied upon the outdated data. Consequently, the valuer was suspended, his registration was suspended for a period of 6 months. So the authority was kind enough that the suspension was just for 6 months and also imposed a penalty for negligence and ordered the fund to reassess the valuation under the supervision of an IBBI approved value. So what are the lessons learned from this case study? So the IBBI's stringent actions underline the importance of due diligence in performing valuations. Valuers must ensure that all aspects of the valuation process, whether it is site selection, whether it is data relevance, and other things as mentioned in the process, are properly adhered to. This is the first case, negligence in conducting valuation. Then case number 2, lack of independence and conflict of interest. So conflict of interest, you understand what is conflict of interest? Conflict of interest. So the incident is that a registered valuer who was appointed to determine the fair value of a company during an insolvency process was found to have prior business dealings with the promoter group of the company in question. So the valuer was suspected of biasing their assessment to benefit the promoters, which would influence the resolution process. So what the regulation action was taken? After receiving a complaint, stakeholders launched an inquiry and found that the valuer had indeed violated the principle of independence as required under valuation rules. And in response to this violation, valuer's registration was revoked and a ban on the future registration for a period of 3 his registration was revoked and a ban on their future registration for a period of 5 years. So, what are the lessons learned? That it reinforces the requirement of independence and impartiality in valuation works. Valuers must avoid situations where there is conflict of interest, as even the appearance of bias can undermine the valuation's credibility and integrity of the process. Third case is related to failure to adhere to the ethical standards. So, a registered valuer was found to have used manipulative techniques in reporting the valuation of an industrial property. Instead of employing recognized methodology and approaches, the valuers overstated the asset's worth to artificially inflate the company's book value for the purpose of raising the additional capital. Now see here, someone has asked that some Section 34 AB registered valuers are doing valuations by using their own methods. See here, So the problem arises when something happens. Otherwise, your valuation is hardly objected to. That is why they are doing. But maybe at certain point of time, if they are not using the requisite methodology, they may face such problems someday. So what was the regulatory actions taken in this case? Upon investigation determined that valuer had violated multiple provisions of the code of conduct outlined in the valuation rules. As a result, valuer was suspended for 2 years, during which time the firm had to undergo retaining program on ethical violation practices. So what are the lessons learned in this case? The case highlights the critical importance of ethical conduct in the profession. The honesty of a valuer is not just a matter of personal integrity, but also to the proper functioning of financial markets. Another case is misrepresentation of valuation for personal gain. In a high profile case, a valuer misrepresented the valuation of an intellectual property as such to inflate its value in a merger and acquisition deal. The inflated valuation was used to justify higher purchase price, benefiting the selling party at the expense of the acquirer. What are the actions taken by the regulatory authority? Upon receiving a complaint and conducting an inquiry, the authority found that the valuer had intentionally misrepresented the assets worth. The registration of the valuer was cancelled, and the valuer was permanently banned from practicing in the valuation profession. See here, the strictest action was taken in this case. तो लालच बुरी बला है वही चीज है. So this case serves as a reminder that misrepresentation for personal gain or financial benefit is severe violation and it is treated with utmost seriousness. Valuers must remain transparent and truthful in their all their assessments. From these we can see the pattern analysis. Number of values have been depaneled. Simply these numbers have been removed just to hide the actual data. We cannot give it the actual data. So n number of values have been depaneled, revealing systematic deficiency in valuation practices. Analysis of recent enforcement cases shows recurring patterns of violations. So it is not that after you have learned these lessons, still the persons are doing the same violations. So that have resulted in severe professional consequences, including suspension, monetary penalties, and permanent disbursement from the practice.
सर आवाज नहीं आ रही.
तो आवाज आ नहीं रही सर?
आवाज आ रही है सर.
आ रही है सर.
मानशु जी अपना सिस्टम रिस्टार्ट करिए. So friends, in this
Audible, sir.
some data names and some figures are intentionally deleted and omitted to not to disclose anything personal for anyone. Yes, sir. Please continue.
So, n number of valuers have been dependent, and along with them, monetary sanctions imposed on violating valuers in major enforcement cases, and most maximum percentage is due process violations. Maximum process problem is here, due process violations. Percentage of enforcement cases involving inadequate documentations and procedural failures. This is where the main problem is. Another case study is fraudulent asset valuation. So it is the valuer failed to conduct physical verification of the assets, relied on unverified information from the management, and significantly overvalued the machinery to facilitate fraudulent transactions.
Mostly in plant and machinery cases, if you rely upon the management data provided to you and information related to machine purchase, billing, and insurance, maybe misguiding you, and you are taking it lightly, and you will not able to visit due to certain reasons, circumstances, whatsoever may be the reasons, then you may be in trouble. This is a best case study for these type of valuers who are relying on the management data provided to them and not able to verify in time. Yes, sir. Please continue.
So in a landmark IBBI enforcement action, the registered valuer was permanently dependent for conducting fraudulent valuation of industrial assets. The case involved systematic overvaluation of manufacturing equipment to inflate recovery prospects for creditors in insolvency proceedings. So, what were the key violations identified? The valuer failed to conduct a mandatory physical inspection of the assets, accepted fabricated purchases invoices without verification. This is a problem. Accepted fabricated purchase invoices without verification. So those who are from plant and machinery, they know these things in detail. Then ignored obvious signs of asset deterioration and inflated the values by over 300% compared to the realistic market assessments. The enforcement order noted complete absence of supporting documentation and failure to apply appropriate valuation methodologies. And this IBBI registered valuer was permanently disbarred from doing the valuation, and the case was referred to the law enforcement authorities for taking further action after potential criminal prosecution. So this case established precedent for zero tolerance towards fraudulent valuation as practices and emphasized the critical importance of professional integrity. So basically, the first thing is fraudulent valuation. So that thing is known to the valuer. That is not negligence. That is done with an intent of defrauding. And then there are certain failures, we have discussed about the methodology failures. That is basically technical incompetence of the valuer. Technical incompetency in valuation methodology represents a significant risk factor leading to regulatory enforcement. As we have already discussed that as per recent IBBI orders, they have highlighted the cases where values applied inappropriate valuation processes and fail to consider relevant market factors or demonstrated fundamental understanding of asset characteristics. So, what are the things in methodology failures? First thing is inappropriate method selection. So, you know there are different methods, different approaches, income approach, market approach, cost approach, and in then also again in income approach there are different methods: profit method, capitalization valuation method. Similarly, in market approach, you have different methods of doing valuation. So, with you should be conversant with all the approaches, with all the methods, and you have to justify the method you have chosen for that particular valuation. It is your duty. You have to justify your selection of the method. For example, you are using income
अभी
approach.
एक सर्कुलर आईबीबीआई ने इशू किया था, वैल्यूअर हैज टू डिस्क्लोज द मेथोडोलॉजीज टू द स्टेक होल्डर्स। अभी तक आप जो वैल्यूएशन दे रहे थे वो मानी जाती थी, नाउ इट इज मैंडेटरी टू डिस्क्लोज द मेथोडोलॉजीज यूज्ड बाय द वैल्यूअर। आपने कौन सा अप्रोच इस्तेमाल किया है? जैसा मैं आपको शुरू से ही बोलता था, आज से 5 साल पहले से भी मैं हम लोग आपको रिकमेंड करते थे कि आपको पूरा क्लियर होना चाहिए अप्रोच आपने कौन सी इस्तेमाल की है और उस अप्रोच में कौन सा मेथड इस्तेमाल किया है टू फाइंड द वैल्यू। इनकम अप्रोच में अगर आपने किया है तो प्रॉफिट मेथड किया है या कोई और मेथड किया है तो क्यों किया है और कैसे किया है, और दूसरा मेथड आपने क्यों नहीं किया, दूसरी अप्रोच आपने क्यों नहीं की, ये सारा मेथोडोलॉजी इसका पार्ट है। नाउ इट इज मैंडेटरी। अगर आपने वैल्यूएशन दे दी, वो एक्सेप्ट हो गई या नहीं हुई, दैट इज इमैटेरियल। लेकिन अगर वो पीयर रिव्यू में आई या आपका इंस्पेक्शन मार्क हुआ और आपने मेथोडोलॉजी उसमें डिस्क्लोज नहीं की, देन आपके ऊपर एक क्वेश्चन मार्क रेज हो सकता है और आप you can be in trouble and you have to listen loud music by them. Yes, sir. Over to you.
As far as an example of inappropriate method selection, for example, you have done valuation with income approach, but the asset was non-income generating, such as an owner-occupied residential house. Or you are applying outdated market comparables without adjustment for current conditions. Now you may be using the right method, but see here in case of sales comparison method, you have to use market comparables, but you are using market comparables which are outdated, or you are using them without applying requisite adjustment for the current conditions. And then there must be maybe some calculation error. So mathematical mistakes in discount rate determination, incorrect application of depreciation factors, or errors in market adjustment calculations. So there may be inappropriate method selection, or there may be some calculation error, or there may be some inadequate analysis. For example, failure to consider market conditions, regulatory restraints, or physical condition factors affecting the asset value. And as we have already discussed, the problem regarding independence and conflict of interest violations. So whenever you are doing valuation, and whether it is for IBBI, whether it is under CEV regulations, whether it is under any regulation, you must check that you do not have any conflict of interest in the asset you are doing valuation. So what are the main thing? It is that valuer must maintain complete independence from the client for a minimum of 2 years prior to the assignment acceptance, with zero tolerance for any financial, personal, or professional relationship that could compare objectivity. And if this thing is not maintained, as we have already discussed, that IBBI and in certain cases CBI have also imposed severe penalties on the valuers who has compromised their independence through financial relationship or prior services or family connections with the client entities. So the regulatory authorities have taken action against the valuers who have accepted assignment where they had previously provided consulting services, maintained financial investment in client companies, or had close personal relationship with key management personnel. So these violations not only resulted in regulatory penalties, but also exposed valuers to civil liabilities from stakeholders who relied on their compromised valuations. Then documentation deficiency. So this is again an important criteria. You have to maintain proper documentation of all the things you have done for that particular valuation. So inadequate documentation represents the most common violation in IBBI enforcement actions, appearing in over 80% of disciplinary cases. Regulatory authorities requires comprehensive documentation to support every aspect of the valuation process from initial engagement through final report delivery. First thing is, as we have already discussed, engagement documentation. So written agreement, as we have already discussed, you must have a written agreement specifying scope, methodology, limitations, and fee arrangements with clear independence confirmations. Then it is your duty to maintain work paper maintenance. So you have to keep detailed records of all procedures performed, sources consulted, calculations made, and judgments exercised during valuation. See, this is important thing of work paper maintenance. And then review and supervision. Evidence of appropriate review procedures, supervisor signs off, and quality control measures implemented. And then thing we have already discussed, once you have submitting the report, what should be there? Complete supporting documentations for all conclusions, assumptions, and market data relied upon in the final valuation report. This is how you have to avoid documentation deficiencies.
Friend, this is most important point. You have to keep in record all data related to conclusions, assumptions, and market data relied upon. अगर आपने कोई वैल्यूएशन किया है और उसका लेट इट बी लैंड बिल्डिंग आपने 1 लाख पर यूनिट रेट लिया है, तो why not it is 99,999 and why not it is 1,10,000 rupees? You have to justify, and for that you have to keep in record that data. Why your conclusions and assumptions are 1 lakh? Why not 10 rupees below? Why not 10 rupees above? And which method and which approach you have chosen to calculate that value? And if it is a leasehold property, why you have not adopted the income approach? Why you have chosen the market and cost approach or any other method? That is your duty to provide the statement and data related to your conclusions, assumptions and market data you are relying upon. अभी आपकी अंतरात्मा की आवाज नहीं चलेगी. इफ यू आर थिंकिंग यार मुझे वहां पर लगा 1 लाख रुपया है, मैं गया था 2 महीने डीलर से पूछा 1 लाख रुपया वहां पर चल रहा है और वहां पर मैंने दे दिया, और अगर आपको कंस्ट्रक्शन रेट है आपने 2000 या 3000 दिया है, तो वो कौन से सीट पीडब्ल्यूडी शेड्यूल के हिसाब से दिया है, उसमें कितना डेप्रिसिएशन लगा है, कितना ईयर ओल्ड प्रॉपर्टी है, क्या एज है, क्या लाइफ है, और क्या आपने कैलकुलेशन किया है. यू हैव टू प्रोवाइड दिस डाटा टू द इंस्पेक्शन टीम. और अभी आपको पता होगा, अभी जैसे ही ये HYR भरा जाएगा, यू विल गेट द नोटिस फॉर इंस्पेक्शन पर्पसेस. All the valuers and some of the valuers may get some other type of notices, and you will get a notice for inspection. And as soon as the notice for inspection will be received by you, there will be a checklist in that notice. You have to complete that checklist, and in that the assumptions and conclusions you have made, you have to report. अगर आपने कोई वहां पर मार्केट अप्रोच इस्तेमाल किया है तो कौन सा डाटा इस्तेमाल किया है, कितना रिलाइड है, कितना नहीं है, ये आपको वहां पर प्रोवाइड करना पड़ेगा. अगर आप बोलेंगे मेरी अंतरात्मा की आवाज है, तो वो बोलेंगे आप अंतरात्मा को लेकर आइए भाई, यहां पर बिठाइए अंतरात्मा को लाकर. अगर आपने अंतरात्मा की आवाज से रिपोर्ट दी है तो उनको यहाँ पर फिजिकल प्रेजेंस में लेकर आइए, यहाँ पर सामने प्रेजेंट करिए और हम उसकी रिकॉर्डिंग करेंगे आपकी अंतरात्मा ने कैसे बोला 1 लाख रुपया है. तो अभी आपको ये समझ के चलना पड़ेगा. नाउ द प्रोसेस, नाउ द थिंग इज नॉट इजी बाइट. अभी आप उसको डबल रोटी की तरह से चबाकर नहीं खा सकते. अभी आपको काम करना पड़ेगा. फॉर व्हाट यू आर गेटिंग द फी, यू हैव टू प्रोवाइड द डिटेल्स फॉर इट एज पर द एक्ट. अगर नहीं तो आप बाहर बैठिए, सिस्टम से बाहर होइए और आराम करिए. यू आर बीइंग रिटायर्ड. ओके, यस सर, प्लीज कंटिन्यू.
Thank you, Sandeep ji, for your valuable input. Next is a case study related to party transaction valuation failure. This is a case of CEV which investigated. So in this case, the registered valuer who provided fairness opinion for a related party transaction involving transfer of valuable real estate assets at below market prices. So it was undervaluation basically. The CEV investigation revealed that valuer had understated property values by an amount crore to facilitate the preferential transaction. So what were the regulatory findings? The enforcement order documented that valuer had applied inappropriate discount rates. See here. So it is your duty to justify if you are using some discount rate, how you have selected that particular discount rate. It is not only the rate, comparable rate in income approach method or in any method where you are using discount rate, what discount rate you are using and why that discount rate? Why not 8%? Why not 9%? And then
केस स्टडी में आपको ये पता चलेगा सिर्फ ओवर वैल्यू देना ही क्राइम नहीं है, अंडर वैल्यू देने में भी आपके ऊपर ऑब्लिगेशन आ सकती है. If you are not providing the fair value, whether it is overvalued or undervalued, you can be in trouble always. Yes, sir. Over to you.
What the valuer has done, he has applied inappropriate discount rate. He has ignored comparable market transactions. and he failed to consider development potentials of the property. See, and these are either these are with intent or these may be without intent. But he has done something wrong. So the valuer also failed to identify and disclose indirect business relationship with the transaction counterparties. So here again the conflict of interest part was also there. So instead of that, it is called related party transaction in CBI under CEV evaluations. The only name has changed, but the meaning remains the same. That we should not have conflict of interest. So the SEBI imposed a monetary penalty of X amount and banned the valuers for accepting listed company assignment for 2 years and required enhanced supervision for subsequent valuations. Sorry. So the case highlighted critical importance of thorough due diligence in identifying potential conflict of interest and carry out the valuations with proper investigation analysis and with the justification of all the assumptions you have.
देखिए, for an example, a fake type example, if the property value is around 5 crore, let it be, and आप सोचते हैं कि I am providing the value of 3 crore, I am 100% safe. अरे क्या करेगा, मैंने तो दे दिया है और कम ही दिया है, मैं सेफ हूं. नहीं, यू आर नॉट सेफ. अगर प्रॉपर्टी की वैल्यू 5 करोड़ है, अगर आपने 5 करोड़ 50 लाख दिया तब भी आप प्रॉब्लम में है, अगर आपने 4 करोड़ 50 लाख दिया तब भी आप प्रॉब्लम में है. व्हाई नॉट 5 करोड़ एग्जैक्ट? आपको किस चीज का फीस मिलता है? 5 करोड़ का फीस मिला है और 5 करोड़ की वैल्यू को करने का फीस मिला है. आप सब्जी भी लेते हैं तो तोल कर लेते हैं, आलू लेते हैं 2 किलो, तो 2 किलो से अगर 10 ग्राम वो कम देता है, आप उसको बोलते हैं एक और आलू डालो. अगर ज्यादा होता है तो आलू वाला एक आलू निकाल लेता है. तो व्हाई नॉट एग्जैक्ट मेजरमेंट, व्हाई नॉट एग्जैक्ट फिगर आप दे पाएंगे? अगर नहीं दे पाएंगे देन यू आर नॉट अ वैल्यूअर, यू आर नॉट लायबल टू बी कॉल्ड एज अ वैल्यूअर. एग्जैक्ट देना चाहिए और एग्जैक्ट आपको मार्केट रिसर्च करना चाहिए, एनालिसिस करना चाहिए, आपके पास फैक्ट्स एंड एक्ट्स होने चाहिए, सारे आपके पास डिटेल होना चाहिए. आपने फिगर तक कैसे पहुंचे? इफ आर नॉट एबल टू प्रोवाइड देन यू कैन बी इन ट्रबल. यस सर, ओवर टू यू.
And then certain banking valuation violation.
अगर आप सोचते हैं कि बैंक की वैल्यूएशन करके मैं 1,000 रुपया या 2,000 रुपया ले रहा हूं, आई एम मोर सेफ देन IBBI स्ट्रीम, हियर यू आर मोर रिस्क इन IBI कॉशन लिस्ट. अगर आपका नाम एक बार कॉशन लिस्ट में आ गया देन योर कैरियर विल नॉट ओनली बी फिनिश्ड, इट विल बी टोटली फिनिश्ड. तो वो ही लिस्ट आज की डेट में IBBI को अगर कोई भेज दे तो आपका वहां पर भी आपका ब्लॉक हो जाएगा. तो बैंकिंग सेक्टर में अगर आप सोचते हैं मैंने जो वैल्यूएशन किया है मैं सेफ हूं, कुछ नहीं होगा, रे यार IBBI को क्या पता चलेगा. देखिए अभी ये IT का जमाना है, यहां पर हर चीज नजर आती है. अगर आपका एक बार गलती से भी नाम कॉशन लिस्ट में आ गया तो योर, अगर आप सोच रहे हैं कि बैंकिंग सेक्टर में रहकर आप सेफ हैं और आपने जो वैल्यूएशन दे दिया 1,000 रुपया 2,000 रुपया लेकर, एक मीयर सा अमाउंट लेकर, एक टोकन अमाउंट लेकर आपने वैल्यूएशन कर दिया तो कोई कुछ नहीं पूछेगा, ऐसा नहीं है. आज की डेट में सारे सिस्टम्स आपस में कनेक्टेड हैं और कुछ भी ऐसा नहीं है जो आपको छुपाया जा सकता है. और अगर आप बल्क में वैल्यूएशन कर रहे हैं देन यू विल बी एट मोर रिस्क. तो अपनी वैल्यू बढ़ाइए, अपना प्रिसाइजनेस बढ़ाइए, अपनी एफिशिएंसी बढ़ाइए और सही वैल्यूएशन दीजिए. अदरवाइज बिल्कुल काम मत करिए. घर में बैठिए, कोई आपको जबरदस्ती बुलाने वाला नहीं है, कोई बंदूक रख के आपसे वैल्यूएशन कराने वाला नहीं है. Plus, don't indulge yourself in more serious complications. Yes, sir. Over to you.
So IBBI caution list, what are the risk categories? First type is professional liability. So basically from the IBBI caution list, what are the things which were taken by the IBBI authorities. It was negligence claims, breach of professional duty, inadequate due diligence, failure to follow prescribed methodologies. As far as professional liability is concerned, as far as regulatory non-compliance, there were violations of prescribed standards, failure to maintain independence, inadequate documentation, non-compliance with the disclosure requirement. And then some criminal cases, criminal liability cases in which there were fraud allegations, criminal conspiracy charges, money laundering implications, asset concealment accusations. So these are the findings from the IBA caution list. So this list emphasizes three primary risk categories that valuers must navigate carefully. So as we have discussed, professional liability, what is professional liability, what type of violations comes under professional liability, what type of violations comes under regulatory non-compliance, and what type of violations come under criminal liability. So you must take care of these things if you are doing valuation for any banking or financial institution. Basically, as a registered valuer and as an RVO, our duty is confined to IBBI regulations, but this is just because all of you are doing valuation for banking and other regulatory authorities also. That is why we are discussing these things. So again, in IBA, as far as professionally liability is concerned, there were certain technical errors and omissions. So we have already discussed problem with methodology selection, method with the market analysis. Basically, IBA has categorized these violations under three categories. So professional liability category, so the violations, which type of violations comes from technical errors in valuation methodology application, computational mark mistakes, mistakes in calculation errors, that is, or omission of material factors. So Indian courts have increasingly scrutinized valuation reports, particularly in cases involving mergers, acquisitions, and insolvency proceedings. So these things we have already discussed. And another thing that is important, assumptions validity. So that is what we have discussed, that whatever assumptions you have made for and doing the evaluations, that must be reasonable. And these assumptions should be adequately supported. Means unreasonable or inadequately supported valuation assumptions should not be there in your valuation process and in your valuation report. Whatever assumptions, whatever things you have done, again here in banking and financial institution valuations, it is your duty to maintain documentation. As in the case of IBBI valuations, here also it is your duty to maintain all the documentation record. So in IBA, it has been found from their caution list that documentation deficiencies represent another significant exposure area. Court expects a comprehensive documentation supporting valuation conclusion, including detailed inspections, limitations, and sensitivity analysis. So these things we have already discussed. These things are again very important if you are doing valuation for banking or financial institutions. And again, the same thing, independence and conflict of interest. So it is your duty to comprehensively screening of all potential conflicts before engagement acceptance. And again, it is your duty to continuously monitoring of independence throughout the engagement phase. And if you have anything like that, then you must have detailed documentation of conflict assessment and independence confirmations. Criminal liability exposures for the value. As far as IBA is concerned, professional valuers can face potential criminal liability when their conduct crosses a line from professional negligence into fraudulent activity.
देखिए आईबीबीआई में एक स्टैंडर्ड प्रोसीजर है, अगर आपके साथ कुछ मिसहैप होता है या आपकी कुछ लायबिलिटी बनती है तो आपको एक प्रॉपर अपॉर्चुनिटी दी जाएगी टू बी हियर्ड। आपको पूरा अपना जो सेल्फ डिफेंस है वो अपने आप को प्रोटेक्ट करने का पूरा राइट आपको दिया जाएगा आईबीबीए में। लेकिन आईबीए में अंडर बैंकिंग सेक्टर ऐसा कुछ नहीं है, सिर्फ कहने के लिए है। एक बैंक मैनेजर के आपसे कोई प्रॉब्लम हो गया, उसने नाम आपका आईबीए लिस्ट में कॉशन लिस्ट में भेज दिया, आपको पता ही नहीं, आपको 2 साल तक पता ही नहीं चलेगा मेरा नाम वहां पर आ गया है, और आपको धीरे धीरे सभी बैंकों ने बाहर कर देना। तो और उसके बाद कोई सुनवाई नहीं है, आपको सीधा हाईकोर्ट जाना पड़ेगा, और हाईकोर्ट में मिनिमम फीस इज 5 लाख रुपीज। तो इतना तो आपने अभी तक कमाया नहीं होगा जो आपको केस लड़ने में लग जाएगा, वो भी डिसीजन आपके फेवर में आएगा नहीं आएगा कुछ नहीं कह सकते। तो इसीलिए बैंकिंग सेक्टर इज मोर रिस्की देन द प्रोटेक्टेड सेक्टर। यस सर, ओवर टू यू सर। Rajvinder sir, are you there?
Yes, sir.
Yeah, over to you, sir.
Am I audible, sir? So, in the criminal liability, there are certain categories. First one is fraud charges. Intentional misrepresentation of asset values with the knowledge of falsity and intent to deceive the stakeholder. So, fabrication of supporting documentation, collusion with the management, systematic overstatement of values. This comes under fraud charges. Then, as far as criminal conspiracy is concerned, coordination with other parties to manipulate violation outcomes for illegal financial gains. For example, market manipulation schemes, insolvency, fraud facilitations, tax evasion assistance if you are doing valuation under CBDT. And then the most important, money laundering. Many times as a valuer, you may face the consequences under this money laundering acts, FEMA, FERA, etc. So participation in schemes to disguise the source of illegal funds through inflated asset valuations. Real estate valuation manipulation, shell company asset inflation, cross-border transaction facilitations. We will discuss these cross-border transactions facilitations in the coming slides. So shell companies, asset inflation or real estate value inflation. Then civil liability, that is professional negligence claims. So beyond regulatory enforcement, valuers face significant exposure to civil liability claims for parties who suffer financial losses due to deficient valuations. Courts have established that valuers owe a professional duty of care to reasonably foreseeable third parties who rely on their valuation for business decisions. So recent court decisions have explained the scope of potential plaintiffs to include creditors, investors, shareholders, and other stakeholders who can demonstrate reasonable reliance on their valuation. See, if you are doing valuation for banking purpose, the money involved here is public money. And if you are doing any fraudulent activity, any violation, you are playing with public money. And that money, there may be certain part of your money also involved there. So, especially when you are doing valuation for banking and financial institutions, you must be extra vigilant, extra careful because of involvement of public money there. It is your duty to save the bank first, to help the bank for which you are doing valuation. Every other person, whether it is bank manager, banking authority, your client, or anyone else comes later. First and foremost person for which you have to do the right work is banking or financial institution for which you are doing valuations. So what happens in this case? Key liability principles. Courts apply negligence standard duty, breach of professional standards, causation, and quantifiable damages. However, the burden of proof is often met through expert testimony demonstrating that values conflict fell below accepted professional standard in methodology, due diligence, or report. And then there are certain allegations against values, market manipulation allegations. So market manipulation allegations represent an emerging risk category for Indian valuers, particularly those involved in listed company valuation, IPO pricing, and merger acquisition transactions. SEBI has enhanced its scrutiny of valuation reports that may influence market prices of our investor decisions. So price manipulation concerns arise when valuation conclusions significantly deviate from the market expectations or peer benchmarks without adequate justification. Values must demonstrate objectivity, methodology, application, and provide comprehensive rationale for valuation conclusions that differ materially from the market indicators. So sometimes maybe that there is certain particular asset where the valuation differ particularly from the market conditions. And in that case, you have to be more careful in justifying your valuation methodology, your conclusions. For example, two buildings were constructed on two adjacent plots on the same date. And after 10 years, one building was sold for 10 lakhs and the other building was sold for 20 lakhs. Same construction was there. So it was because the building which was sold for higher value, that was well maintained. But the building that was sold for 10 lakh, that was not maintained properly and it has undergone large amount of physical depreciation. Though it's the life of both the buildings is same. So here, that is where if there is certain deviations of such types, you have to make the things, justify the things why such difference in valuation exists. That is your duty. So insider trading implications may arise when valuers have access to the material non-public information that could affect security prices. The SEBI prohibition of insider trading regulations imposed strict restrictions on trading activities and information confidentiality requirement for valuation professionals. So what are the preventional strategies you should do? First thing is implement robust Chinese wall procedures. No information should leak from your office and you should maintain a proper confidentiality of all the records you have got. Maintain detailed assumptions documentation, conduct thorough market analysis, and regular methodology reviews and updates. What are the red flag indicators in such cases? Unusual client pressure for specific conclusions. Have to avoid that. Abnormal fee arrangement or payment terms. When someone is giving you fee higher than what is which is normal fees or beyond your expectations, it means there is something wrong. So inadequate access to the information or management and compressed timelines without justification. That the client is asking you to do the evaluation within 2 days or within 1 day. Should take adequate time because you need time for collection of data, analysis of data, and only then you can provide the valuation. ठीक है संदीप जी, we can have a short tea break. Am I audible, sir?
Yes, you are audible.
Yes, sir. Yes, sir.
Yes, sir.
Yes, sir. ठीक है संदीप जी, we can have a short tea break.
Yes, sir.
Okay, sir.
So friends, let's take a short tea break of 15 minutes. It is around 11:35. We will join sharp at 11:50. Till then, you can switch off your screens. 11:50 will be the attendance time.
Okay, sir.
So next is professional indemnity insurance can. As a professional, you can have professional insurance. Certain insurance companies, they are providing professional insurance to the professional, to the engineers, to the doctors, to the valuers. So for safe, you can do professional, you can have professional indemnity insurance, but I think none of us have applied or taken this insurance. So professional indemnity insurance coverage represents a critical risk mitigation tool that many Indian valuers inadequately understand or improperly structured. The insurance market for valuation professionals remains underdeveloped with limited policy options and significant coverage gaps that expose practitioners to substantial financial risk. So standard professional indemnity policies often exclude specific risks relevant to the valuation practice, including defense cost, regulatory penalty coverage, and civil liability arising from insolvency proceedings. So these exclusions can leave valuers exposed to significant financial consequences when facing legal challenges. So coverage amount adequacy has become a critical concern as penalty structures and damage awards have increased substantially. Many values maintain insufficient coverage limits that may not be adequately protect against potential liability exposures, particularly in high value commercial assignments. So retroactive coverage considerations are often overlooked, potentially leaving values exposed to claims arising from past assignments. So the regulatory frameworks evoking natures mean that current assignments may face future liability exposures under revised standards or interpretations. So there are n percentage where number of values who are having no coverage, insurance coverage or inadequate coverage. So certain amount has been prescribed as minimum recommended coverage for commercial valuation practitioners, and percentage of policies with significant exclusions not understood by policyholders. So our RVO and some other RVOs are also trying in this field, trying hard, and are doing consultations with insurance companies to have consultations regarding adequate and sufficient policies at reasonable insurance premiums.
Even
And another problem is
IBBI के प्लेटफॉर्म पर भी 2 मीटिंग्स हो चुकी हैं with different insurance companies to provide the professional insurance to valuers. Let's wait for them कि क्या decide होता है. अगर ऐसा होता है, it will be a remarkable step taken by them. Yes, sir. Over to you.
So this thing we have already discussed risk assessment, engagement risk assessment framework. So here both client as well as the valuer have to take care of certain things. First thing is, as far as client is concerned, client should investigate the client or the client should investigate whether the valuer who is doing valuation is having adequate qualification, adequate registration with the competent authority, and have adequate experience to carry out the assignment. And as a valuer, it is not that as a valuer you should also check the client's background, their financial stability, litigation history, regulatory compliance record, and management reputation if you are doing valuation of a firm through independent sources. So both valuer as well as client should have due diligence about each other. So if you have done this thing, half of your work is done. You are doing, you are doing valuation for the person who has for a firm or a person who have a litigation history, or you firm which does not have do not have financial stability. He does not have a good reputation. So these things are related because if some person is having some litigation history or a firm is having litigation history, so that thing can land you in trouble sometime. So another thing is you have to check the assignment complexity. All the assignments are not the same. Each and every assignment is different. So evaluate technical difficulty and check the asset type. Check it that the particular asset of which you are doing valuation, you are competent to do that. And then valuation purpose. For which purpose you have to do the valuation, you know, with a change in purpose of valuation, the whole procedure will change. Then regulatory requirements you have to check before proceeding, and timeline constraints against available resources and expertise. So if you have enough assignments, already have enough assignments, and you know you cannot do justice with another assignment, or you cannot complete it within stipulated time, so simply say no to just next assignment. Otherwise, that thing may land you in trouble because in a rush you can do something wrong. Then it is your duty to independently verify all the data which is given to you by the management, all the data you have collected from the market. You have to check all these things. You have to verify all that and confirm the absence of prohibited relationships, financial interest, or other circumstances that could impair objectivity or create appearance problem. And then you have to check the competence assessment. You verify possession of necessary skills, experience, and resources to complete assignments according to professional standards and regulatory requirements. Maybe you are having a
Yeah, please continue, sir. Sorry to disturb.
So next is client relationship management risk. So many things we have already discussed. First thing is whenever you got some assignment, you should have engagement letter, and that letter should contain all the information regarding scope, definition, clauses and liability protection measures, etc. regarding the assignment. And then whenever you are doing valuation, it is not a single day's work. It may take an n number of days to complete your task. And during execution of valuation process, you should have regular status updates with the client, and you should do whatever you can do for the validations of assumptions you have made for doing the valuations, and should have regular communications regarding management expectations and procedures. It does not mean that you have to do the valuation, give the valuation according to the management expectations, but you can have discussion with them regarding scope of valuation or other things. And then you should maintain independence regarding your professional judgment. You should check conflict of interest, identify conflict interest if any, and commercial pressure resistance. Means you should not do the valuation as per the requirement of the client. You have to do everything as an independent valuer without any bias. So you should maintain a proper client relationship. So that is a significant source of if you have done anything wrong in this, you may have to face legal action. It may land to your legal exposures. So inadequate engagement letter terms, unclear scope definition, and insufficient client communication can result in disputes, liability claims, and regulatory violations that threaten our professional practice substantially. So these things you have to take into career. Another thing is most important thing is fee. So amount of fees to be charged and how it is to be paid, that should be made clear at the start. So fee arrangement structures can create potential liability exposures, particularly contingent fee arrangements that may compromise independence or create conflict of interest. So the regulatory framework restricts certain fee structures, and violations can result in sanctions and professional liability claims. So what are the fee structures which are restricted by the regulatory framework? Anybody must have studied
The one
ethics.
where the fee is dependent on the outcome of the valuation or the amount quantum of valuation.
So one thing you have studied is success fee. That the fee, such an amount of fee will be paid if on the basis of your valuation, the client is able to get whatever he wants. That is called success fee. So that is restricted by the regulatory authority. So this thing we have already discussed is written engagement letter. It will essentially protect you from legal ramifications. So comprehensive written engagement letters serves as the first line of defense against legal exposure by clearly defining scope, methodology, limitation, and responsibility. So regulatory authorities consistently cite inadequate engagement documentation as a contributing factor in enforcement actions. So what are the critical elements that should be there in the engagement letter? Every engagement letter must specify the exact assets to be valued, valuation date, purpose and intended use, applicable standards, methodologies to be employed, access requirement, fee arrangement, and delivery schedule. The letter should also include explicit limitations on liability, restrictions on report distribution, and disclaimers regarding market conditions. So, well-drafted engagement letter allocate risk appropriately between valuer and client, including provisions for client representations about asset ownership, legal status, and information accuracy. So they should also address potential conflict amendment procedures and termination rights to protect both parties. So next thing is due diligence standards means information verification. That is very important for all types of assets. First thing is initial information request. So comprehensive data request covering financial statement, asset records, legal documentations, and operational information with specific representations. So as a valuer, you must give initial information request to the company or the client to give you comprehensive data covering financial statements, asset records, legal documentations, and operational information with specific representations. And then once you got that, it is your duty to verify the sources. So independent confirmation of key information through public records, third-party sources, and direct observations wherever feasible. And as a valuer, you have to carry out consistency analysis, cross-referencing information from multiple sources. So that is important. Cross-referencing information from multiple sources to identify discrepancies, inconsistencies, or potential red flags requiring further investigation. And then documentation standards. So complete documentation of all verification procedures performed, sources consulted, and conclusions reached regarding information reliability. Next is technology and data security risk. So this is where we lack, especially land and building and plant and machinery. They lack in this data security risk. Because we are having little knowledge about statistics, how the data is to be classified, how the data is to be used. So that is why you should have adequate statistical capability. So first thing is, whenever you get some data, you should know how you can classify the data based upon the information, systematic classification of sensitive informations, then how to store the data so that only the competent persons have access over the data. You know, in today's scenario, data storing and saving the data from unauthorized use is very important. Your data may be leaked without your information if you are connected with the internet. You know. So it is your duty to save your data from unauthorized access. And then incident response, comprehensive incident response plans with regulatory measures. And vendor management, third party service provider due diligence on and ongoing monitoring system. So as on today, you know, the technology related risk have emerged as a significant concern for Indian values as digitization increases and data security requirements become more stringent. The Information Technology Act 2000, Personal Data Protection Bill provisions, and various sector-specific data protection requirements create compliance obligations that extend beyond traditional valuation practices. So you know the data breach incidents involving sensitive valuation information can result in regulatory penalties. Even if the data is leaked without your information, and if something wrong happened because of that, it may land you in trouble. So it is your duty to store the data in such a way that it is not unauthorizedly accessible to anyone.
देखिए,
Another problem is
अगर आपके ऑफिस से आपके एम्प्लॉय से भी कोई डाटा लीक होता है किसी कंपनी का और वो उसको मुश्किल होती है, तो विकेरियस लायबिलिटी का क्लॉज यहाँ पर आता है अंडर कॉन्ट्रैक्ट एक्ट। तो यू आर रेस्पॉन्सिबल। आप ये नहीं बोल सकते कि मेरे एम्प्लॉय ने किया, बिकॉज एम्प्लॉयज इज अंडर यू। तो एम्प्लॉयर की जिम्मेदारी है वो डाटा को सेफ रखना। इसीलिए अपना डाटा कभी भी, जो किसी भी कंपनी का जो डॉक्यूमेंट्स हैं, उसके क्रेडेंशियल्स हैं, उसके कॉन्फिडेंशियल बैलेंस शीट्स हैं या कुछ और डाटा है, ऐसा एक आप अगर देखेंगे, मैं नाम नहीं लेना चाहता इस प्लेटफॉर्म पे, ऑलरेडी एक केस हो चुका है और उसके बारे में बहुत सीवियर उनको कॉम्प्लिकेशंस भुगतनी पड़ी हैं वैल्यूअर को, और काफी उसमें काफी बड़ा हाई लेवल केस था और उस केस में काफी प्रॉब्लम्स आई हैं। तो अगर डाटा आपके ऑफिस से किसी से भी लीक होता है, या हो सकता है मैलिफाइड इंटेंशन करके आपका एम्प्लॉय किसी से मिलकर या किसी और नियत से डाटा कहीं भेज देता है, तो भी आप रेस्पॉन्सिबल हैं, क्योंकि वो डाटा सिर्फ आपके पास है। आपके ऑफिस से कैसे लीक हुआ दैट इज इमैटेरियल, लेकिन आपके पास जो डाटा है वो अगर मार्केट में कहीं विजिबल होता है, देन यू आर रेस्पॉन्सिबल, फुल्ली रेस्पॉन्सिबल। देयर आर certain acts and rules regarding that. Yes, sir. Okay. Please continue.
So another problem is that many times those who are conversant with today's scenario, cloud computing. So many times that data is stored over clouds. So cloud computing adoption has introduced new risk categories, including data sovereignty risk, third-party service providers reliability, and cross-border data transfer restrictions. So the regulatory framework regarding data localization and processing requirements continues to evolve, creating uncertainty for technology and valuation practices. Another thing is cybersecurity incident response capabilities are often inadequate among smaller valuation firms, potentially exposing practitioners to regulatory sanctions and civil liability. The RBI's cybersecurity guidelines and other regulatory requirements mandate specific security measures that many values have not mandated. So if you are storing your data on cloud computing or any such platform of third party, it is your duty to check their capability. And in that case, you have to refer to the RBI guidelines and other regulatory requirements so that you can have specific security measures. But for smaller valuation firms, it is not possible to implement such measures.
देखिए
That
कुछ
all things
ऐसी
come with some cost.
यस देखिए कुछ ऐसी फेक वेबसाइट्स हैं, फेक नहीं कहेंगे लेकिन कुछ ऐसी वेबसाइट्स हैं जो आपको डाटा फीड करिए तो आपको एक वैल्यूएशन रिपोर्ट तैयार करके दे देती। तो अगर आप वहां पर अपना डाटा शेयर कर रहे हैं और उसकी हेल्प ले रहे हैं देन इट इज वेरी वेरी डेंजरस। या कुछ ऐसे ग्रुप से आप मिले हुए हैं जो कि आपसे एक डाटा फीड करने के बाद आपको पूरी प्रिपेयर्ड रिपोर्ट देता है। बेसिकली वो आज की डेट में आपको फैसिलिटी लगती है लेकिन इन फ्यूचर दैट कैन बी ट्रैप फॉर यू। वो आपका डाटा कहाँ पर इस्तेमाल करेंगे, कैसे करेंगे, इन फ्यूचर वो अपना डाटा बैंक इकट्ठा कर रहे हैं। तो आपको उस केस में ज्यादा प्रॉब्लम आ सकती है क्योंकि वो डाटा तो ऑलरेडी आप शेयर कर रहे हैं और इंटेंशनली शेयर कर रहे हैं। वो बीच में आपसे डिस्क्लेमर भी साइन कराते हैं। then you will be at more risk and vulnerability will be there for you to entangle in some legal complications. Yes sir, over to you.
मेरे को कॉल आई थी कैसी,
जी काफी आती है सर, सभी वैल्यूअर्स को आ रही है कि आप हमें ज्वाइन
बंदा
करिए।
बोलता है कि आप जो इतना टाइम करते हो 30 मिनट में आपको वैल्यूएशन दे देंगे बना के। मैं कहा सर पहले हम बड़े डिग्रेड हो गए हैं और डिग्रेड क्यों कर रहे हो? ये बोलो कि 30 दिन लगेंगे वैल्यूएशन बनाने में तब जाके फीस मिलती है। अगर
जी।
कहेंगे 15 मिनट में वैल्यूएशन दे रहा फिर फीस किसने देनी? किसी ने नहीं देनी।
और वो आपको फ्री में देते हैं वो सारी फैसिलिटीज, क्यों दे रहे हैं? देखिए फ्री में कुछ भी नहीं मिलता, कहीं ना कुछ हिडन आपसे ही लेते हैं वो। तो ऐसे चक्करों में मत फंसिए कभी भी।
मैंने इतनी बुरी तरह उसको भगाया वो याद करके भी कौन बंदा टकरा आगे से।
जी बिल्कुल बिल्कुल सही आपने।
सर आपसे रिक्वेस्ट है कि एक मतलब ऐसा प्रोफार्मा या कोई
सर सारा
केस
कुछ यूट्यूब पर अवेलेबल है, आप उसको देखेंगे, सिर्फ कमेंट मत करिए। वहां पर जो वीडियोस हैं उनको देखिए, सब कुछ मिलेगा। एवरीथिंग इज ऑलरेडी प्लेस्ड देयर। हमें पता है आपको क्या चाहिए। वी हैव ऑलरेडी सर्व्ड ईच एंड एवरी डिश इन योर प्लेट। लेकिन आप उसको देखेंगे तो पता चलेगा। आप कटोरी के ऊपर ढका हुआ, आप उसको खोलेंगे नहीं, आपको क्या पता चलेगा अंदर खीर है कि सब्जी है? थोड़ा उसको देखिए, कमेंट करके काम नहीं चलेगा सर, थोड़ा सा वीडियोस को देखिए। हर चीज अवेलेबल है, ईच एंड एवरीथिंग इज अवेलेबल। ओवर टू यू सर, प्लीज कंटिन्यू।
So another field in today's scenario, is artificial intelligence. So artificial intelligence and automated valuation tools, as Rakesh Kumar ji has said, these are automated valuation tools. You fill the data, they prepare a valuation report for you. They are being increasingly used in valuation practices. creating new liability exposures related to algorithm bias, model validations, and professional judgment delegation.
अगर हम ये बोलेंगे कि एस्टिमेट हम एडिट करके बैंक को दे दें तो बैंक बोलता है इसका 300 रुपये मिलेगा। जब आप उसे बोलेंगे हम कोई डिटेल में बनाएंगे
Sir,
आपको
we will not
2500
discuss.
3000 मिलेगा।
Sir, this platform is not meant for this. Please follow the what our slides are saying. This platform, we cannot discuss fee structure on this platform. We will discuss in some personal meeting. Please continue, sir.
So, whenever you are using, of course, you can use artificial intelligence, but make sure when you do valuation, first thing is any program. First thing is that from you should know from where the AI has taken data. It is persons like you and me who have given them the data. It is not that they have automatically generated. So many times you can get reference. Yesterday I was searching for something and they gave me that on CEV news portal this thing has been given. And they have taken this data from there. So it is we who are giving them.
आजकल सीवी पोर्टल्स इतना ज्यादा इंफॉर्मेशन प्रोवाइड कर दिया है, अभी तक 50 इयर्स में इतना इंफॉर्मेशन नहीं है जितना सीवी के पोर्टल्स पर अवेलेबल है। तो आप कहीं भी सर्च करिए वैल्यूएशन से रिलेटेड, आपको एक ना एक सीवी का न्यूज या यूट्यूब वीडियो या कुछ ना कुछ वहां पर मिल जाएगा। यस सर, ओवर टू यू।
So you do not take the valuation directly from whatever automated valuation model has given to you. So another thing problem is that whenever you are doing valuation on certain automated valuation models, or you can say any software which is providing you valuation. So as you know, as an engineer, if you are doing structural designing with any software, let us say with the StatPro, so it will design on the basis of the data you have provided. If you have given him wrong information, he will not use his brain. He will design it according to the data you have given. Similarly, here the case is. So you have to be very, very, very careful if you are using these digitized platforms. One thing is procedure, and second thing is that whenever you give the data to them, they will use your data in any other case also. They will store it on their platform and will use your data. Definitely use your data in other cases also. Next thing we have already discussed, physical inspection requirements. So you know that is very, very important whenever you are doing any type of valuation. Physical inspection requirements have become increasingly stringent for enforcement cases where values relied solely on photographs, management, representation, or desktop analysis. So regulatory authorities now mandate personal observation of assets in most valuation contexts, with limited expectations requiring specific justifications. So what are the things you have to check during your physical inspections? So any type of asset you are doing, whether it is real estate, whether it is machinery and equipment, or whether it is you are doing valuation on the basis of inventory. These things require personal observation with photographic documentation. So whenever you are doing the valuation of real estate or machinery, you have to check its condition of the asset. These condition assessment protocols you have to follow. And then you have to check environmental compliance verification, whether the asset is following environmental regulations. And in case of plant and machinery especially, you have to check operational status confirmation. And next is remote inspection exceptions. So limited circumstances where physical inspections may be waived with appropriate disclosures and risk assessment. Then it may be due to security or safety restrictions, or due to geographic impossibility, or asset disposal prior to valuation. So in certain cases, you can do valuation with remote inspection, but you should make appropriate disclosures and do such valuation with the proper risk assessment. Then documentation requirements. So comprehensive records of inspection procedures, findings and supporting photographic evidence you should take at the time of inspections. Time-stamped photographs. So nowadays many apps are there where you can take, on which you can take photographs with the time, location, altitude, everything is over the photographs. One such app is the timestamp with which you can take photographs, so that you can attach with your valuation report. All of you know these things. Then condition assessment forms and third-party verification wherever possible. And then many times, if you are doing cross-border valuations, what are the cross-border valuation complexities? So cross-border valuation assignments present unique legal risk for Indian valuers due to multiple jurisdiction requirements, foreign exchange regulations, and international reporting standards. So until and unless you are having knowledge of all these things, foreign exchange regulations, international reporting standards, etc., you should not involve yourself in such cases. The Foreign Exchange Management Act liberalized remittance scheme provisions and bilateral investment treaty requirements create complex compliance obligations. Transfer pricing implications often arise in cross-border valuation assignments involving related party transactions, intangible asset transfers, and business restructuring activities. So another thing is international sanctions compliance has become increasingly important as global enforcement activity intensifies. Valuers must implement systematic procedures to identify sanctioned entities, prohibited transactions, and restricted jurisdictions that could expose them to regulatory violations and criminal liability. And another thing is foreign regulatory compliance requirements. When Indian valuers provide services for overseas entities or transactions involved in foreign assets. So these requirements can create additional liability exposures and compliance obligations that extend beyond Indian regulatory framework. Another problem in such cases is currency valuation and exchange rate consideration. Introduce technical complexity that requires specialized expertise and careful documentation. Reserve Bank of India's foreign exchange regulations impose risk-specific requirements for cross-border transaction valuation that must be carefully navigated. So, what are the FEMA compliance areas? If there is any overseas direct investment valuation, foreign portfolio investment assessment, external commercial borrowing valuations, overseas acquisition due diligence, and non-resident investment compliance. Risk mitigation strategy, how you can reduce the risk in such cases. You should have jurisdiction-specific legal consultations, then comprehensive sanction screening of the valuations and assets, multi-jurisdictional insurance coverage, international standard methodology adoptions, and enhanced documentation procedures. So for market data verification and analysis, you know it represents a critical vulnerable area where valuers face significant enforcement risk. Recent IBBI and SEBI's actions have highlighted cases where valuers relied on outdated, manipulated, or irrelevant market information to support their conclusions. Professional standards required independent verification of all market data through multiple sources, appropriate adjustment for differences between comparable transactions and subject assets, and explicit disclosure of data limitations. Valuers must maintain comprehensive documentations to their market research process and judgment factors applied in data selection and adjustment. So you can verify the data with the government records, industry databases. You must check with industrial benchmarks. These are especially relevant in all the asset classes. Then broker's opinion and management information. So whatever data you got, you have to verify it from the multiple resources. There may be a number of resources. These are certain resources such as government records or industry databases, broker's opinion, and management information, etc. Next is the valuation report standards and disclosure requirements. After you've done all the procedures, you have to prepare and submit a valuation report. What are the standards you have to follow in preparation of this valuation report? And what are the disclosures requirements in the valuation? So valuation reports, you know, it serves as the primary evidence of professional competence and compliance with the regulatory standards. Enforcement actions consistently identify inadequate reporting as a major violation category, with specific requirement varying across regulatory context, but sharing common elements of methodology, disclosure, assumptions, identification, and limitation statements. First thing, your valuation report should have executive summary. So what should be there in the executive summary? It should contain clear statement of valuation conclusion, purpose, effective date, and key assumptions with appropriate qualifications. Then your valuation report should contain methodology and explanation regarding the methodology you have used. Detailed description of appropriate approaches used, rejected alternatives. So not only the tail of the approach, why other approaches were not used means rejected alternatives. And rationale for final methodology selection that you have to do. And then market analysis, comprehensive discussion of market condition, comparable transactions, and economic factors that is affecting the value. And then it must mention the limitations and assumptions you have made, explicit disclosure of all significant assumptions, limiting conditions, and potential uncertainty affecting the conclusions. Then quality control and review procedures. So systematic quality control procedures provide essential protection against methodological errors and professional oversights that could trigger regulatory enforcement. Leading valuation firms have implemented multi-level review processes that address technical accuracy, compliance verification, and report quality before client delivery. Once it is prepared, then it is checked by different authorities within the valuation firms, such as it is to be checked by the senior manager review. It will check the technical methodology and calculation verification. Then managers will check work paper completeness and documentation standards. And the staff which will be preparing initial analysis, research, and calculation. After doing all this, after preparation, after managerial review, after senior managerial review, will be the final sign off by the competent person. So each review level must be documented with specific reviewer comments, resolution of identified issues, and sign of confirmation. Independent technical review may be required for complex assignments or high-risk clients with the external expert consultation when specialized knowledge is required. For example, if the property or asset it involves some valuation assignment which are affected by environmental aspects, where you have to take a third party help. So all these things should be checked at each level before it is being sent to the client. The important thing is that your evaluation report should comply with the international valuation standard. So Indian regulatory increasingly expects compliance with international valuation standard and other globally recognized professional standards. Valuers must demonstrate familiarity with the international best practices while ensuring compliance with the local regulatory requirements that may impose additional obligations. So it is not only the international valuation standard, you have to take into consideration the local regulatory requirements. So cross-border transactions and in multinational client relationship create additional compliance complexity where valuers must navigate multiple regulatory jurisdictions. So recent enforcement cases have highlighted the importance of understanding applicable standard hierarchy and resolving conflicts between different regulatory requirements. So key international valuation requirements are market value definition and application, valuation approach selection criteria, professional competence standards, independence and objectivity requirements, reporting and disclosure standards, and quality assurance procedures. Now we will discuss the things for different asset classes which as a valuer should take care. And if you are a real estate valuer, you should take special care of environmental assessment, zoning compliance, title verification, and market analysis requirements. This is where most of us are lacking. And if it is a plant and machinery, you must take care about the technical condition assessment of plants and machinery, of soil inspectors, and specialized market knowledge requirements. And if the valuation is being done for intangible asset by some SFA values, we must take into consideration legal protection verification, economic benefit quantification, and remaining useful life assessment. And if the valuation is done by SFA values for financial instruments, they must check market liquidity assessment, credit risk evaluation, and regulatory capital requirements. And if the valuation is being done for business enterprise, then the valuer should check financial analysis, market positioning, management quality, and industry dynamic assessment. So then if you have in any case landed in a litigation, then how to carry out so that least possible problem is there. First thing is, whenever such thing happens, immediate documentation, preservation, insurance notification, and legal counsel are engaged. If you land in such trouble, immediately find out the document related to the assignment. Then check if some insurance can be done, or if you have a professional insurance, inform the insurance company, and also engage a legal counsel. Then you carry out, do not panic in such cases. First thing is, do not panic in such cases. And then you check the assessment, case assessments regarding technical merit evaluation, financial exposure analysis, and defense that on the basis of all these things, you design your defense strategy. And then try to find whatever things you can use in your defense, such as document production coordination, deposition preparations, and expert witness identifications. So whether it is you who are appearing as expert witness, or you can have another person which you may be using as your witness or as an expert witness, and prepare for the trial. For trial, you need evidence organization, witness preparation, and courtroom presentation strategy development. So these are the things if in any case, due to any reason, you have landed in a litigation. So these effective litigation strategies are very essential for the valuers who are facing challenges in India's increasingly complex dispute resolution environment. The National Company Law Tribunal, various high courts, and specialized firms require specific defense approaches that must be carefully coordinated and experienced legal counsel. You need experienced legal counsel to help you. So early case assessment procedures enable valuers to identify potential defense strategies, evaluate settlement opportunities, and develop a comprehensive litigation management. And when the situation arises, you have to appear in the court, or you may have to take the help of some expert witness. So expert witness preparation has become critical as courts increasingly rely on technical expert testimony to evaluate valuation disputes. And the most important thing is that will come to your help is documentation preservation. And if you have preserved the proper documentations, it will help you a lot. And immediately upon getting the notice of potential litigation, you should collect all the relevant documents and physical records. And it is only possible if you have properly saved all the documents. And then if there is some possibility of settlement negotiation strategies that must balance immediate resolution benefits against potential precedent setting implications and professional reputation considerations. For that, to save you from such litigation processes, the thing which you are doing today, that is professional development and training. That is most important. That is why the IBBI had made it is one of the reasons to save you from the litigation, future litigations. You should have professional development and training. You should update yourself regarding the methodology development and industry best practices. You should have knowledge and increase your knowledge, sharpen your knowledge regarding technical skill enhancement, regarding risk management education, and regarding professional certification maintenance. So as far as technical updates is required, you must sharpen your knowledge continuously in the methodology developments and industrial best practices being changed from time to time. Regulatory changes. Every day some new regulations are being introduced, especially by IBBI. And you must be conversant with the recent changes So these are legal requirements and compliance obligations. And then on the basis of your continuous professional development, you will have a knowledge to how do you have this risk management, means liability prevention and defense practice techniques, and technological applications. You must sharpen your knowledge regarding digital tools and automated valuation systems, but with the care that the data you use in these things is preserved at any cost. So you, as already done, what you should do in case of any such incidents, immediately on such a problem, within 24 hours, you should carry out an incident assessment, team activation, and initial stakeholders notifications. Then within 1 to 7 days, you should help the investigation. You should have legal strategy development and communication planning. Within 1 to 4 weeks, you should have regulatory cooperation, settlement negotiations, and reputation management. And for long-term strategy, you should practice reconstruction, system improvement, and preventive measures implementation. What are the best practices which you should have in order to save yourself from such a legal risk? First thing is engagement controls. Means have a written engagement letter for all assignment, independence confirmation procedures, client background verification protocols, scope definitions, and limitation documentations. Then technical standards you should maintain within your firm and of course within you yourself. Methodology, selection documentation, market data verification procedure, physical inspection protocols, calculation accuracy. Then for quality controls, you must have multi-level review requirements, work paper documentation standard, report format and disclosure compliance, compliant communication documentation. And of course, the main thing for risk management, you should have professional liability insurance coverage, data security and confidentiality measures, continue education compliance, and regulatory update monitoring system. Then from where you can get the resources and support system, can have support from the professional organizations as your RVO, CEV, IAF RVO. Then can have data or requirements from the International Association of Consultant and Valuers, American Society of Appraisers, and Royal Institute of Chartered Surveyors. From where these are some professional organizations from where you can get a lot of things to save yourself from legal risk. Then for technical support, you can have specialized valuation software providers, market data services and databases, industry research and analysis resources, expert consultation services. For regulatory compliance, you must consult the websites of IBBI, official guidance documents, CEV valuation regulations and circulations, International Valuation Standard Council, and of course, professional liability insurance carriers. And legal and compliance, you should have professional liability defense counsel, regulatory compliance consultants, ethics hotlines and guidance services, peer review and quality assurance programs. It means you should have a strategic risk management framework that will provide a foundation for sustainable valuation practice in intense complex. So we have discussed all the things regarding the risk assessment methodology. Means whenever you do any assignment, you should carry out risk assessment to evaluate engagement specific risk, client risk related exposure, and regulatory compliance requirements to guide engagement acceptance. You should have all these things. Legal protections means comprehensive liability mitigation through proper documentation, insurance, and defense practices. You should systematically adhere to the all applicable laws, regulations, and professional standards. You should have a robust quality control system within your firm, ensuring technical excellence and professional standards. You should carry out continuous education and skill enhancement to maintain technical competence, and stakeholders management. It is again very important things. Means effective client relations, regulatory cooperations, and professional networking. So in the end, we can say that we can have excellence through compliance. Means legal risk facing valuation professionals have never been greater, but they can be effectively managed through disciplined adherence to professional standards, comprehensive risk management procedures, and proactive compliance monitoring. The enforcement actions and regulatory penalties examined in this guide demonstrate the serious consequences of professional shortcuts and inadequate attentions to the regulatory requirements. What are the key things you must learn from these things we have discussed? That a professional success in today's regulatory environment require unwavering commitment to independence, methodological rigor, comprehensive documentation, and continuous professional development. Valuers who invest in proper systems, procedures, and expertise will not only provide regulatory enforcement, but will also provide superior services to the clients and stakeholders. So the valuation profession continues evolving towards higher standards of accountability, transparency, and technical competence. So you should have compliance excellence means systematic adherence to all applicable regulations and professional standards. You should continuous learning, skill enhancement to meet evolving industry requirements, and you should have everything in place for risk management, comprehensive systems and procedures to identify, assess, and mitigate professional exposure. Thank you very much for listening to this presentation.
So
So
friends,
if you have
if
anything to discuss, we can discuss it here.
yeah,
Ji,
if you
Sanjeev.
are having any doubt related to this, if we can discuss here, then we will move to the next session.